So we're going to start out, we've got a lot of speakers, they're all going to go fairly short, and then we're going to have questions at the end. So if you can hold your questions, make notes, then we'll have a question and answer session at the end. We're going to start out with Michael Vaughn from the BC Civil Liberties Association, who's going to give kind of a background overview on SLAPP suits. And then we'll have Jason next, I believe, who's has been a defense counsel in a number of SLAPP suits, including the Vancouver Sun one, but also the Botany Northwest Organic SLAPP suit. And then Neil is going to speak about the Burnaby Mountain SLAPP suit. And Alan is also a defendant from the Burnaby Mountain SLAPP suit. He's going to speak about that and about anti-SLAPP legislation. So that's a quick overview. And I'll pass it on to Michael.
Okay. Hello, nice to be here. So I've been asked to give a little bit of an overview about SLAPPs, which are, of course, strategic lawsuits against public participation. So that is when big resources, a person or a group with wealth, power, and legal resources, brings a frivolous or dubious lawsuit against little resources, citizens who have been critical of big resources, typically. The idea is to shut down the critics, right? That's the purpose of a SLAPP suit. The merits of the suit itself are absolutely unimportant. The lawsuit can be completely ridiculous, and it can succeed in its purpose because the process is the punishment. Defending a lawsuit against a powerful litigant is enormously costly. Time, money, and emotional energy. I'm sorry I don't have current data on this, but I can tell you that a few years ago, a survey conducted by Canadian Lawyers magazine reported that the going rate for a 2-day civil trial was over $25,000. It is certainly not an exaggeration to say that the threat of a lawsuit can rise to the level of an attack on a person's fundamental well-being. And their consequences for a democratic process are equally dire. Because of this, we urgently need protections against SLAPP suits. So I believe that one of the main discussions here is going to be about corporate intimidation. But since I'm tasked with giving an overview, I thought I should at least tell you that there are notorious cases of SLAPP suits brought by governments against citizens. Yes, it's eye-popping, isn't it? See, first time I heard this, I did that same thing. So I'll give you some examples of what those might look like. In 2005, Donald Page, a retired engineer and civil servant, was sued for defamation by the Ontario Township of Montague for making a complaint about the local fire department to the Ontario Fire Marshal. Okay, I'm going to run that by you just one more time. Sued for defamation for a complaint to the Fire Marshal about, among other things, inadequate training of volunteer firefighters. Sued for making a complaint about fire safety to the governmental body statutorily mandated to receive citizen complaints about fire safety. Right? It's gobsmacking. It would be patently absurd if it didn't have actually happened. And so you'll be thrilled to know that the township was not successful in the claim that it brought for $50,000 worth of damages against Mr. Page. But what it cost Mr. Page personally to defend himself against that, and the repercussions for the citizens of that township in terms of the chilling effect on their public participation is uncertain. We don't know. We certainly know that that legal precedent was not sufficient to deter the city of Powell River from trying their hand at the same tactic. Some years ago, the city of Powell River threatened to sue some of its local citizens for defamation, again, the notorious go-to for SLAPPs, although not the exclusive civil suit for SLAPPs. The city of Powell River attempted to sue for defamation for statements of concern that had been expressed about the utilization of public funds and election proceedings and conflict of interest of some of its elected representatives. Now, it's really hard to imagine a libel chill, any chillier or more corrosive of the democratic process than a government suing its own citizens for criticism of the government. And our read, the BC Civil Liberties Association, is that there really is no legitimate action for defamation by any part of government of Canada against its own citizens. In that, we agree with Mr. Justice Corbett in the Halston Hills case, who wrote this: "When a government is criticized, its recourse is in the public domain, not the courts. The government may not imprison or fine or sue those who criticize it. The government may respond. This is fundamental. Litigation is a form of force, and the government must not silence its critics by force." Litigation is a form of force. And citizens participating in public discussions need protection from this form of force, need statutory protections, and here's the irony in the context of British Columbia. We used to have this. Don't feel bad if you missed it. It only lasted about 8 minutes. We had at one point, and our organization, the BC Civil Liberties Organization, participated in the quite extended debates and consultation process that resulted in an act called the Protection of Public Participation Act. Shortly afterwards, a newly elected government killed it as quickly as it could and as quietly as it could, in fact, in the dead of summer when no one was paying any attention. Now, the government's argument for doing so, and the argument of the government continues to be that there is no need for such a law in British Columbia. Their insistence is that courts are well equipped to deal with vexatious litigation. That's their position. Our position is that there's no basis on which to ground this conclusion, that our courts are indeed not currently equipped to deal with SLAPPs. What the government claims is that the procedural rules that courts have to dismiss frivolous lawsuits are of assistance to SLAPP defendants. In this case, they say we need no anti-SLAPP laws. However, the evidence is mounting all around us that this is simply untrue, and many, many other jurisdictions have seen the wisdom of providing these kinds of protections to citizens. And I'm talking about, bastions of progressive ideals like Utah and Texas. Okay? We are way, way, way behind in terms of acknowledging that we have a serious problem with public discourse in this realm. So, what do anti-SLAPP laws do? What would that look like? Well, they provide disincentives to persuade parties from bringing SLAPPs in the first place, is the notion. Right? You put some speed bumps. You can't guarantee that nobody is going to bring a lawsuit of this kind, but you make a disincentive. And what you try to do is you try to weed out those illegitimate claims from legitimate claims early on in the process, and to minimize the financial burden on the defendants whose cases would not go forward because they're being adjudicated with this heightened scrutiny, because there's a sense in which there's a preliminary threshold, you have the indicia, you have some criteria that you're meeting to suggest this might be a SLAPP suit, you get a heightened sense of scrutiny at the front end of the process to prevent you from being dragged through that very costly proceeding. So, examples of this. If a defendant, and this is just, again, generic notions of what anti-SLAPP legislation seeks to do and what our legislation did for 8 minutes. If the defendant can show that the proceedings challenge a category of protected communications, right? Public discourse discussions about topics in public purview, political discussions, etc. The onus then shifts to the plaintiff to prove that the lawsuit is legitimate. Right? Again, just trying to shift the onus earlier on in the process to have that examination of legitimacy. And if the question of the lawsuit's legitimacy cannot be effectively determined at the outset, then you have other mechanisms like the potential for advanced or interim cost provisions that would allow the courts flexibility to address the needs of the defendants who don't necessarily have substantial economic resources. In fact, in our definitions of SLAPPs, massively ill-paired in terms of the economic resources of what they're up against. But anti-SLAPP laws, for all that we need them, are not the only reform that we as an organization would call for to protect public participation and free speech. Defamation laws need to be completely overhauled in our view and made legitimate and intelligible to the average person. They are currently not even intelligible to the average lawyer, I can assure you. The BCCLA is not alone in calling for substantial changes to BC's libel and slander laws. We say those laws must take as a first proposition the protection of free expression. That's the starting point. And then that categories of qualified privilege and fair comment should be greatly expanded to reflect that. We also say that as an example of how you would go about protecting the public discourse, that damages should be reduced to nominal levels, except where income loss on the part of the plaintiffs can be demonstrated and where profit on the part of the defendants warrants punitive damages. These are just some examples. How could we shape this to be more protective of public discourse? In fact, there are all kinds of things that could be done. The entire notion of having criminal defamation, we're talking about civil suits, but just over here for your overview, FYI, there is something called criminal defamation. It's a different avenue for a SLAPP. And we note, our association has noted, with appropriate concern, that the inevitably, and historically, it is critics of the police who the police decide should be charged with defaming or them criminally. It's appalling. In a related area, we've recently seen very troubling attempts to severely limit public participation at the National Energy Board hearings, despite a legal requirement to provide for meaningful public participation. So in short, there's a lot of things that we need to do. But ultimately, probably our discussion here today will focus on civil suits that are SLAPPs, fall into that definition. And as I say, we feel that one of the biggest advances we could make is to lobby for the appropriate statutory protections. But we'll probably talk about that a little more after we've heard from everybody else. So that's my time. Thank you.